The Supreme Court of India, in the matter of state represented by Inspector of Police versus ELURI SRINIVASA Chakravarthi, allowed criminal appeals and set aside the impugned orders and prayers of discharge by looking at documents brought on record. Court said that it is borne out by the record that plea for discharge is founded on correspondence dated 8 January 2007 and 31st January 2007. Thereafter, by referring to very gist of communication, prayer for discharge had been made. In clear terms and reasoning, discharge had been ordered not by referring to any of situations in sections 239 of CRPC but by relying on documents made available by the accused. The procedure followed by trial court and as confirmed by High Court was patently illegal and contrary to the binding precedent. Passing remark by High Court in common order that there was no material for cheating and forgery belies the existence of allegations and documents. Consideration of the material, that is, charge sheet and list of documents in backdrop of allegations made against the accused, is available path for discharge by special court and High Court. But a path unavailable for the special court and the High Court is consideration of material invited at instance of the defense of ordering discharge. The orders impugned proceed on assumption of the absence of loss to the Cotton Corporation of India on basis of letter dated 31st January 2007. The case of prosecution established looks at wrongful gain through conspiracy and forgery to defraud CCI and farmers to the tune of 21 crore 19 lakh 35,646. Non-compliance with discretionary limits as set out under section 239 of CRPC warrants interference of the Supreme Court. On 27 of June 2006, CBI Vishakhapatnam registered FIR under sections 120B read with 420 of Indian Penal Code 1860 and sections 13.2 read with 13.1D of Prevention of Corruption Act 1988. The registration of crime was against one Rayapati Subbarao and few other unknown individuals. Between November 1994 and May 2006, accused one served as cotton purchase officer in Cotton Corporation of India Guntur branch. Alleged offences for which suo motu FIR was registered by CBI were said to have happened in financial year 2004-5. The CCI, as part of policy, buys cotton at minimum support price on a year-to-year basis. CCI for financial 2004 to 2005 released policy of MSP through its letters. The modus operandi, briefly stated as per prosecution, was that A1 and A3 allegedly purchased cotton from genuine farmers at lower prices before announcement of MSP by Government of India, and they hoarded these cotton stocks. Once CCA started purchasing cotton at MSP, A1 with the support of A3 resold the hoarded cotton under Benami names of farmers A4 to A47 to CCI at higher MSP rates. These transactions occurred at Pericherla and Firangipuram in Guntur district and Madhira in Khammam district, where accused one was in charge CPO during the year 2004 to 2005. Many of the farmers allegedly did not have sufficient land to cultivate large quantities of cotton they purportedly sold to CCI. A few of the accused did not have cultivable land at all, while a few others had very small holdings, and volume of cotton sold at MSP is disproportionate to their land holdings. Bank accounts were opened in name of these farmers, often introduced by A3 or his employees. Payments from the Cotton Corporation of India in the form of checks were routed through these accounts and allegedly were encashed and utilized by A3 and A2 by forging the signature of farmers on takpattis and katta chitta, the payment slips. Pertaining to Firangipuram, the investigation revealed that the thumb impressions were used on the relevant material, whereas the said person acknowledged through signature in English or Telugu. The prosecution alleged that wrongful loss under the MSP for a sum of 21 crore 19 lakh 35,646 crores to the CCI Government of India, and the wrongful gain was to the accused person. Premise of accusation was that MSP is meant and intended for cotton farmers and growers, and through the alleged modus operandi it had been subverted for the accused for gain. Court stated that it is correct that Union of India versus Prafulla Kumar Sammal and another case lays down the standard for discharge of an accused under section 239 of CRPC. Application for principle of documents relied upon by special court and high court was both debatable. Discharge under CRPC is salutary, and the magistrate, through the expression used in these sections, is under an obligation to discharge the accused where, from the charge sheet and the appended documents, it is noticed that trial of such charges is worthless. Therefore, to sustain the exercise of discretion, order of discharge conforms to the requirements of these sections. Jurisdiction conferred on the magistrate by Section 239 CRPC was appreciated from the language of the said provision. In a civil suit, triable issues of fact or law are culled from a material proposition of fact or law affirmed by one party and denied by other, and the issue in a civil suit is an admixture of a case to parties to the list. In contrast, Section 239 of CRPC, which deals with the trial of warrant cases by magistrate, confines the examination to final report and documents sent with it under Section 173 of CRPC. The allegations in the FIR, transformed through investigation and collection of evidence, are shaped into a final report. This receives attention of the magistrate to decide whether charge so presented against the accused is groundless. The salutary duty fastened on the magistrate is exercised not only for aborting unwanted and groundless prosecutions but also for ensuring continuation of prosecution of a final report with documents presenting a triable charge. Considering the importance of either discharging the accused or continuing the prosecution, magistrate neither acts as a post office nor conducts a mini trial of the report and the documents before it while exercising the power under Section 239 CRPC. The learned magistrate, in sufficient measure, examines the report and documents while taking decision for discharge or for proceeding with the prosecution. Court said, we propose to examine whether the impugned order before us withstand the scrutiny and requirement of this court. However, since the order of discharge is amenable to jurisdiction of revisional court, order of discharge must speak for itself, and only a warranted conclusion is arrived at by the magistrate. Deviation from the discretionary limits definitely attracts supervisory jurisdiction of revisional courts. The issue of whether discharge is warranted or trial is continued depends on circumstances of each case.